And today, I'm going to talk about the Port Russekk case. The issue concerned is whether notification of readiness can be served by email. So you may think that it's a very straightforward answer, but this case may come as a surprise to you. So under a charter party, there is constant information transmitted between the owners and charterers every day. For example, the notice of readiness, delivery with delivery notices, cancellation notice, and other daily reports. The method of delivery, i.e. how these documents are to be transmitted to the other, is sometimes of very crucial importance, as well as the time when you send those documents. One example is the notice of readiness. It's a very important document. It triggers the running of daytime. So the valid delivery of the document and the time of delivery are very important. Sometimes the charter party itself may specify the method as to how you deliver the document. But there are gray areas. An example of that issues may arise is whether electronic communication, i.e. email, is a permissible delivery method. The Port Russekk case talks about this issue. The background of the case is quite simple. The issue was first decided as a preliminary issue in an arbitration. The issue then was appealed to the UK Queen's Bench Division Commercial Court, and the judgment was delivered very recently, in March 2013. The facts of the case: the charterers voyage charter a vessel from Baltic ports to Western African ports to carry a cargo of clean petroleum products. The charter party concerned was the amended BP voice reform. There was a demurrage dispute at the end, and in that case, the NOR was served by email. The relevant issue for the tribunal and the court to decide is, was email a contractually permissible method for serving notice of readiness under this charter party? Relating to this issue, there are two main charter party clauses in this CPU which relates to this issue, and we have to look at the wording quite closely in order to understand the tribunal's reasoning as well as the court's reasoning. The first clause is clause 19. The clause essentially talks about notice of readiness, and the important words are those underlined. Such notice of readiness may be given either by letter, fax-email transmission, telegram, telex, radio, or telephone, and if given by radio or telephone, shall subsequently be confirmed in writing, and if given by fax-email transmission, confirmed by telex. So these words talk about how you deliver the notice of readiness. There are six methods stated there, but as you can see, email was not one of the specified methods in this clause. So another relevant clause is clause 23. It talks about the demurrage claim. It said charterers shall be discharged from liability from demurrage claim unless the demurrage claim was presented to the charterers with supporting documents. And then at the end, it said the owner's demurrage claim should be addressed to Traffic PTE, care of Falcon Navigation Corp, with an address given. But importantly, at the end, it says email. There's an email address, email demurrage.claims@trafficguru.com. So this seems to suggest for demurrage claim, as opposed to notice of readiness, then the party intent email can be used. So the first is decided as a preliminary issue in the arbitration, and the tribunal's decision was that email is a contractually permissible method to serve NOR i.e. the tribunal agree that serving the NO by email, that's perfectly okay and valid. The tribunal said the BP voice form was first introduced in 1990, and at that time, my recollection was that there was no email at that time. And also at that time, fax was not yet very common. So that's why in the BP voice form, it says for fax email transmission, then it has to be subsequently confirmed by telex. That is the background when this clause was drafted, this BP voice free form clause 19 was drafted. So the tribunal's view was that although serving NOR by email was not mentioned in the clause, it does not mean that they are not permissible. There are also some comments from the tribunal. The tribunal said, we all agree with our arbitral colleagues that the probability is that Clause 19 has never been updated to reflect the introduction of emails, which is probably true, that at that time there's no email, and then subsequently there's no update, which reflect the introduction of email. The tribunal also said, it's clear that the original authors of Clause 19 emphasized and intend that NORs might be tendered in a wide variety of ways. The majority, i.e. the majority of the tribunal, cannot believe that the original authors intend their list to be exhaustive or exclusive. The tribunal thinks, because there are 6 ways listed there, then the original intention must be that, the NOR can be served in a wide variety of ways. The third one is very important. The tribunal also said that had the original authors of the form been asked whether if in the future a new way of tendering a document in writing were to be invented, would that be permissible? The tribunal thinks the answer that the original author would have been yes. That means the intention back in 1990, when we asked the author what they intend, they must agree that in the future, if there is some other way which is common for serving document, that they should also be allowed under this form. So that is the tribunal's reasoning. The decision then was appealed to the court, and the court disagreed with the tribunal and held that email is not a contractually permissible method to serve the NOR. The word may in clause 19 could mean a permissive or obligatory clause, and each case depends on its context. We have to look at the clause from time to time in order to understand the reasoning of the court. So the court said the word may, such notice of readiness may be given, can be permissive or obligatory, depending on the context. Permissive means it may be served in this particular way, but also in other ways it's okay. But obligatory would mean that the notice of readiness has to be or shall be served in the 6 ways mentioned. But whether it's obligatory or permissive, depending on the context. And in that case, the court find that Clause 19 was prescriptive, obligatory, and exclusive. Essentially, the clause defines and confines how NOR must be given in accordance to the 6 communication methods listed in that clause. The court's decision may come as a surprise to many people in the field, but the reasoning of the court is actually quite strong. The court has given 6 reasons to support its decision. First, it said the words either and or appear in the clause. And usually when people say either or, it denotes alternatives which constitute an exclusive group. So that if I say either this or that, that means these 2 are exclusive. Anything else is not is not permitted. So that we look back at the clause, it says either by letter, facsimile, transmission, telegram, telex, radio, or telephone. So that the intention is that these 6 are an exclusive group. Anything else are not permitted. Second, the tribunal said there's little point in the court said there's little point in listing 6 alternative methods if any other method was permissible. I.e., if like anything you can serve it in whatever way, then it's no point to list out 6 alternatives. Third, clause 23 was amended to the clause we looked at about the demurrage claim was amended to allow email communication, but there was no similar amendment in clause 19. So that must mean that when they draft clause 23, they intend email can be used. But no similar amendment in clause 19 means that the party's intention must be that they did not intend email can be used for serving NOR. Fourth, the issue of commercial certainty. The court said the deeming of NOR has important commercial and financial consequences. It triggers the lay time and affects the amount of demurrage, so that the parties properly wish to have certainty as to how the documents was to be served. The fifth reason, regarding the 6 methods listed out there, there's a common feature among them. That is, in all that 6 methods, there will be something, a hard copy would produce. There will be something in writing at the end. But for an email, if you send it to the other side, unless you print it out, then there will be no hard copy. But why a hard copy is important? Because the receiver can then make some endorsement or comment on the NOR. And the court also said that the giver of the NOR may then benefit from the absence of any endorsed rejection or comment on that document. The sixth reason, the word no or otherwise was not there. So if clause 19 was intended merely to enumerate and not restrict the methods of serving NOR, then one would expect, after listing the 6 alternatives, the word or otherwise will be there. But those words are not there, so that other methods are not intended. The court also commented on the tribunal's reasoning. The court said the tribunal erred in focusing on what the original author of BP Voice 3 form might have intended in early 1990. The court said that that's not a correct approach. The court said what matters is the party's intention in 2007 when they entered into this particular joint party. At that time, they were well aware of the existence of emails as a communication method. But then they chose to only refer it in clause 23, but not amend in clause 19. So the tribunal thinks then the intention of the party must be that they didn't want to allow email to be used for NOR. But in reality, it's more likely that the parties didn't really think about how to serve NOR in their case, or simply have assumed that email was allowed under the BP Voice 3 form. So what we can learn from this case, so email is now a very common method for communication. But is it necessarily a contractually permitted method? The answer must be no. And the answer must be not necessarily. And whether email is contractually permitted very much depends on your on the CP clause, on how you draft your charter party. So what happens if you not just charter party, but any contract. If you have a clause which lists out certain methods of communication, but email was not there, then what you should do? You should consider the factors. First, does the clause intend to limit the number of communication methods? Second, does the clause provide the word or otherwise at the end? If so, if the word or otherwise appears, then email will probably be allowed. Or did the clause say as agreed otherwise? And in that case, you will probably need to then agree with the other parties whether email can be used. Third, do other clauses allow email communication? If other clauses allow communication, but not the clause, the clause in question, then that is a strong indication email is not allowed, because the party amend the other clause but not the relevant clause. Last is hard copy communication, likely intended by the parties. Then you consider those factors and think about whether email is actually allowed. But to be on the safe side, the tips would be, if you want to use email when you draft the contract, expressly set that out. And if the contract has been agreed already, and the relevant clause doesn't really say about email, then use those methods expressly state to avoid any disputes. So just a short conclusion. Basically, I've covered them. Whether email is contractually permissible, look at the CP. And then the choice of words in CP are important. Clear language, as always, clear language should be used. And finally, despite emails being used daily in our lives, do not readily assume they are always allowed under the CP or under the contract.